Well, hello students and welcome to the Week 8 lecture for LW305 for 2024. Today we're going to start off with some discussion of your individual plan and what I'm expecting from you in your individual plan. I'm going to go through the instructions and I'm going to go through some examples of graded student plans from previous years and go through some of the feedback that I provided to them, which might well end up being familiar to you because I will repeat myself when you receive your feedback for your plan. If you submit your plan on time, that is by this Sunday, then you should receive your feedback by the following Sunday. I'll probably release them all together, either late in the week or on the weekend. But the idea is that we will turn around the plan feedback quite quickly. What that will mean is that your position paper will take longer to mark, but you've already submitted that, so there's nothing you can do about that now. Forget about it. Your new focus is the plan, and then your focus is the essay. And so we'll turn around the plan feedback very quickly, and we'll get the position paper feedback to you when we can. So let's go to that first, and then I'm going to come back and give an overview of this fairly short lecture and say one or two small things about your essay, and that will be it. You should also see on Moodle that there's a link to a detailed discussion of the Week 8 readings. I've also uploaded a detailed discussion for the Week 9 readings and for the Week 10 readings. All of those should now be available to you on Moodle. I'm also going to I'm going to try to record your additional lectures, your Week 9, 10, 11, and even your Week 12 lecture, and try to make those available to you as soon as possible over the next 2 weeks so that you have access to the full course and the content well in advance of your submission date for your assignment. So with that said, let's move on to having a look at some examples. Okay, so you should all be very familiar with this document. This is your assessment portfolio. And if you think you already know all of this and I've got nothing new to say, then skip ahead. I did say a whole lot of this in the Week 1 lecture, but let's repeat it here. So for this essay, you are picking a piece of legislation. It could have been passed 100 years ago, but it needs to be something that has reportedly not been functioning well, and you need to provide some recent evidence. This is current developments in Pacific law. So, what's been coming up recently? Laws relating to family and domestic violence have a long history of reform and maybe not working properly, and lots of challenges for governments in the region. But these are laws that criminal laws have existed since, time immemorial. We've always had these in our countries. And, but there's been new laws. There's been family violence laws, domestic violence laws, child protection laws, and other laws that have been brought in to try to specifically address those issues. So what you're then looking at is, this was passed in 2002. There's been lots of reforms, but this law on domestic violence, we still have a huge problem. It's not working. And here's some evidence showing from 2021, 22. Look at all these, problems during COVID. Look at the ongoing statistics showing rates increasing, which shows increased reporting, not necessarily increased incidents. And this is a current issue, right? So link legislation you choose to what's actually going on in society. What are people talking about? What is a problem? Online safety laws, environmental protection, climate, other things, right? But climate change is not a law. An Environmental Protection Act is a law, but be very careful in not mixing up what the intention of a law is versus what you claim it to do. An Environmental Protection Act wasn't established to prevent climate change. It probably wasn't established to mitigate the effects of climate change. And so, again, if what you want is something that's specifically on those issues, you'll need to find legislation related to specifically those issues. So you all want to be lawyers, so go find the legislation that you want to write about. I'll leave you to read the assessment instructions for the paper. You should be familiar with them. In terms of the plan and what's due this Sunday, you have 5 marks that you can gain, and you can get that if you include the relevant headings and provide some sort of roadmap to me for how you're going to write your essay and what your essay is going to say, its content, its structure. You have a maximum of 3 pages because I can't turn around marking for 100 papers in a week if they're any longer than that. If you're all writing 10 pages, then I have 10 times 100, 1,000 pages to go through and provide detailed feedback on. There's only so many hours in the day, and I can only commit so many of them to marking your papers. So 3 pages, this is a plan, but to get the best feedback from me, give it your best shot. Work really hard on this, because the harder you work, the better the feedback you'll get, or the more relevant the feedback you get will be. And at this early stage, hopefully you can then apply that feedback to really improve the essay that you're going to write. And I really encourage you to do that. Hopefully you already are doing that. In terms of how you're going to be assessed, well, I have said you must include an abstract, and I'll come to that in a moment. And the purpose of that is to encapsulate your whole argument in a single paragraph. As law students, you don't do abstracts. Some of you might have never done one. Most of you have probably had to write an abstract for something. But also most of you have summarized text. Most of you have probably summarized text not even using large language models before. So that's great, because the next generation of students might never, ever summarize anything by themselves. But an abstract's more than a summary. So it's effectively a mini essay. And so I'll come to talking about that here in just a moment using this resource. But what I want to see from you is a draft abstract, a legitimate attempt at structuring your arguments and explaining to me how you're going to structure your arguments. So I'm just losing my place here. And I want to see that you're going to have the right headings. You're going to have a section where you discuss, where you identify the weaknesses that you will address using the Guy Powell's minimum standards framework. I then want to see that you recognize that the majority of your essay, 1,500 words of it, the 1,400 words of it, most of it will focus on the 1, 2, or 3 weaknesses that you've chosen to focus on, and will explain your best approach to strengthening that law. And I want to see that you recognize and understand that that's where all of the marks for your paper are going to come from. You can see here the marking criteria. I have encouraged you to take some time to review your paper against this, okay, the majority of your marks are coming from how well you write, how well you research, that you use a coherent structure, and that you do use the Power Minimum Standards framework, and you do engage in critical analysis of strengthening law. So do note that, because this is worth ultimately 15% of your grade, and the majority of it is coming from that. Okay? So let's focus then on the abstract and writing an abstract, and then we're going to come to 2 examples that I will run through of previous work. So this is a resource. You can just Google this, University of Adelaide writing an abstract. You might find other resources that are more useful for you. This seems pretty good. A lot of abstracts information on the web relates to scientific papers, and it'll have methods and it'll have findings and results. That's going to send you in the wrong direction. This one won't send you in the wrong direction because it's focused on humanities, social sciences, law type essays, right? So what is it? Well, an abstract either describes a paper or it informs a reader about a paper or issue that the paper addresses. It's really useful because there's a lot of papers out there and people are busy. And one of the best ways to figure out whether a paper might be relevant to something you want to say is to read the abstract. If people don't have abstracts, you have to read the introduction, but that might not say everything that it needs to say. It might not tell you about the conclusions. It might not tell you about why this particular issue is so significant. It might just be an introduction to the paper and how it's structured, because that's what an introduction is. So a good abstract, coherent, it's a paragraph, 150 to 200 words maximum, and stands alone as a unit of information. You don't have any references in an abstract. You shouldn't. Sometimes you might see them, but you shouldn't. It's effectively a concise mini version of your paper. So you can even write some of these things sort of down. It sort of does say methods and results. Let's not worry about those. I thought this was a bit more focused on humanities here. But purpose, the focus, and essentially what your paper finds. And we're going to, again, come to some examples here. So this is actually probably more like what you need to be doing rather than this. Okay? So this is more of a science paper, and you might have done this back in school where you had to write lab reports or something for science. This, and this is then a small version of that bigger lab report. This is more what you're doing. We're still, that says 50 to 100. We're still, I'm giving you the leeway of up to 200 words. The background, the purpose, the focus, and something about the contents. And here's a couple of examples. Now, I'm going to leave you to go through this yourself, Google it yourself, pause the video here and read this if you like. This is an example of a descriptive abstract. You can see on the side here how, this is a bit like what I've done with my structures or my suggested structures for your position paper. That this should be your background, and somewhere around here should be the body, and somewhere around here should be the conclusion. These are just descriptors. I'm going to talk more about that later. And here's an informative one. Okay, so you can see here it's a lot longer. Here it's talking about a full study. So, less emphasis on here, more emphasis on here. And maybe more emphasis on the examples I show you. This might be really relevant to a lot of you. What's the difference between an abstract and an introduction? Well, background, purpose, maybe methods, results, or findings. You can include for your abstract something about what your findings are, right? What your conclusions were, what the paper's conclusions are about strengthening the law. That you have these weaknesses, and this paper considers 3 approaches to strengthening weaknesses in the Human Rights Act. 1, 2, 3. That's it, right? That's your abstract. That tells the reader, that's what this paper does. That might be relevant to me. I'm writing about human rights. Let's see. And there's a bunch of other resources that you could go to there. Okay, so that's a little bit about writing abstracts, and I'll talk more about that through the examples. So here you'll see the first example. Your cover page doesn't count as a page, right? Don't email me to ask that, please. Okay, so here this student has given us this is their abstract. Now, some of you might know that this act has, I think, been repealed by the now current government of Fiji. But this is a few years ago, and this is what this student was writing about. So the Media Industry Development Act was introduced as a decree, okay, to regulate media organizations and improve the development of media, okay? And you can see I've done a few little language corrections in here just to sort of make it a bit stronger. This paper, it doesn't aim to, the paper identifies. Use the active voice. The paper identifies strengths and weaknesses using this framework. That's what this paper does. Key weaknesses identified using this framework include the 3 key weaknesses that I'm going to identify. Pad that out, flesh that out. This paper will then refer to, no, you don't refer to, you will use, this paper will use international and comparative law approaches, or using these, it then identifies key strategies or mechanisms or ways for strengthening the Act and assesses their impact in addressing those weaknesses. Great. So fleshed out, not bad. They're improve the development of media. Is that what the Act was to do? It does say develop, but is that what it was for? I don't know. It just seems a bit vague. The development of media, what does that even mean? The development of the economy, the development of agriculture. What does it mean? Are we building new sugar mills? Are we legalizing growing marijuana crops finally in Kandavu? Because that's just going to happen anyway on the highlands or anywhere else. Are we legalizing it for general production and use overseas? Are we growing industrial hemp? Is that how we're going to develop agriculture? Or are we getting more cows? Try to be specific and clear. Your abstract is a challenging exercise for you as a law student to strengthen a skill which is critical for you, and that is the ability to be clear, precise, and accurate in what you say and how you try to convince people. Now, there are some issues, and I'll come to them in this draft, but international and comparative approaches, well, that's one approach for looking at how other countries might have addressed similar issues like media, but that doesn't, that's part of reforming law. So that's not by itself an approach. It's not the only approach to strengthening law, and you need to draw on more than one approach. And this student identifies that they might want to do that, but it's not necessarily so clear. So here's their outline. Okay, cool. In your paper, that might end up being a bit too much detail. I don't need to know the gazetted date. I don't need to know the commencement date unless that's especially relevant. Not that relevant now. Not that relevant now. So already there's sort of, maybe that's a thing to say, that you slip that in. But you can see there's sort of already a few things entering this introduction that are starting to sort of be a bit, I don't know. We're getting a lot of noise in amongst the signal that I want to hear from you. Okay. Well, at some point, you're going to need to tell me in detail what Section 22 does and how it's applied or whatever else, because that's clearly, if this is what this paper's identified, then this is the problem, then whew. But what's the weakness? What is the issue? So nothing here actually says what any of the issues are. It doesn't really, it doesn't introduce the paper. It doesn't say the structure of the paper with pals. It doesn't say what's going to be argued, etc. What you should be doing in the introduction is signposting for the reader what the structure of your paper is. I want to know when I read your introduction, so what is this about, right? What is the problem? And how are you going to present to me your approach for, identifying that problem and addressing that problem? That's what I want to see. This student has used this layout, strengths and weaknesses, using Guy Powell's minimum standards framework. It's not just minimum. So again, get this right. Little things will irritate me. I've been reading this for 8 years now, and everywhere it's referred to as the Guy Powell minimum standards framework. The minimum standards for short, but this is a formal written thing. And of course, please, who is Guy Powell's? Don't tell me, but reference him. Or, better yet, reference Anita Jowett. And the article that I showed you, I believe last week, or in previous weeks, where she comes up with her explicit statement of the Guy Powell minimum standards framework. You need to quote Anita. You need to have a pinpoint reference to the page number for that quote from that article. Because I'm reading this. Pretend I'm just somebody in the street who's picked up your essay, or pretend that you've actually, published this somewhere, and it's going to be published in the newspaper, and other people are going to read it. They're going to look at it and go, well, what's Guy Powell's? What's the framework? What is this? Why did you do that and not something else? Well, give me a link. I've applied this framework. Here's a reference, right? What is explain it briefly. Again, Anita Jowett has a great quote. And then apply it. Now, this is a bit of a brainstorming exercise here. So I would not structure your essay. I would not use a heading for strengths. I would not use a heading for weaknesses. And I would not use, that's sort of, you can do better than just, if what you're writing about is the MITRE or the MITRE Act, analysis of MITRE Act applying Guy Powell's minimum standards, or weaknesses of MITRE Act applying Guy Powell's minimum standards, or whatever. I don't really care about the strengths. Your entire essay is focused on identifying a weakness and arguing how to address that weakness. The more you say about strength, the less words you have to talk about the weaknesses and how you're going to address them. So that means none of that gets you any marks. It's nice. It might look good, but it won't get you any marks because that's not what your task is. And this student has sort of said various things here. So obviously all of this, so complaining about instances, the complaints mechanisms, what you're going to have a detailed discussion of that. How many hundreds of words is this going to take up? I don't care about the things that this act does. I care about the things that you're saying it doesn't do, based on some recent evidence that you can point to from the last 3 years. And, and that's what you might work into your introduction. Something saying, news reports, blah-de-blah, or, a recent publication by the government identified that, or a recent report by Amnesty International, whatever it might be. The student is doing well in sort of looking at, well, is it appropriate? Is it available? Is it responsive? Is it understood? So this is a really useful exercise for you to do to get your head around the act. But these are the weaknesses this student has identified. It's not responsive. Why? It's not responsive to society's needs. Well, why? The legislation was introduced as a way to control media organisations from negative reporting about the government, or interim government. Okay. That's probably not what the interim government says the purpose was. That might have been the effect. But you need to not editorialise this. If you're saying the law is not responsive, then, well, why? All right? Or how? How is it not responsive? What is society's need? I don't know what the society's need is. You're telling me this isn't responsive to it, so you must know that it's not responsive to society's need. So you tell me, well, what does society need? We should have media laws that are what? Enable... Is it that we need media laws that enable complaints mechanisms? Is that what the key thing is? Because it seems it does that well. So what is it that it's not responsive to? It's not well understood by those it seeks to govern. Is it not? Is that the case? The drafting is vague and broad and difficult to understand. It costs thousands in legal fees. Well, okay, again, do you have any evidence of this? What's your evidence that any of this is true? That's just a general sort of statement. Was it really not well understood? I'm pretty sure the Fiji Times staff who, repeatedly stood there with, government representatives and military officers standing over them as they finalized publications. I think they understood quite clearly what the law was. So again, is this correct? And dispute resolution's not fair and effective, so certain acts and decisions can't be challenged. Well, that's definitely not fair, probably. And something about that to explain. Okay, good. Well, okay, so coming up with a recent example that shows the weakness or the weaknesses that you want to address might be useful, or coming up with some just recent media references and explain. Unlike what's been happening a lot in the forums, when you use a reference, it's not just blah, 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 blah. Oh, here's a link. One, reference correctly. If you don't know how to do that, there's a style guide. That's the correct way. I can't stress enough that you must use a style guide. You will get your submissions rejected from court if the margins aren't correct. Literally. So if you don't cite cases correctly, if you don't cite journal articles correctly, books correctly, that will mean you are referencing incorrectly. That will mean your reader can't identify or find whatever it is that you've said as a source. And it means that you're sort of not demonstrating you understand what the point is of supporting what you say with some sort of reference or evidence. Okay, and so then the students come to in their structure, key strategies for strengthening MITRE. Well, repeal it. So my comment here is that repeal isn't an approach for strengthening law unless you're saying that there needs to be a new law. Although this student says that there's no real need for any regulation of the media. I would argue that there is need for regulation of the media. Like any institution, they have responsibilities to society. If there's no regulation, how do you specifically prosecute them? How do you specifically ensure that they're not causing harm? Can anyone set up a media organization? You set up, Truth Social and off you go, or is that a social media platform? It's a bit different. Journalists go to university and get 4-year degrees. They have principles of ethics that they must follow. There's a whole thing, right? There's an entire industry there, like lawyers, like accountants, journalists, etc. Right? So don't, maybe as a lawyer, tell me that industries don't need regulation, because quite literally as a lawyer, your entire job is dealing with laws that regulate society. So if you're going to start saying, oh, we don't actually need laws, we don't need this, you're saying, well, we don't need lawyers, we don't need you. So what are you doing here? Why are you trying to become one? You might say we don't always need law. I say that, but media probably needs to be regulated. Students said that they're going to, so repeal it. That's how you're going to strengthen it. Bit more. I don't know if the Universal Periodic Review, even if it might call for the repeal of it because it's got issues. Again, I don't know if that's where you're going to find approaches to strengthening the law, but it might be. And it says it's going to imply comparative approaches. So, okay, there's all these human rights standards, but what are those standards? Fiji's also got a constitution with a whole list of human rights. So what specifically, if you're saying to me that this act is weak and has problems because it's not fair, then you're saying that something about the laws, some sections of this act, some process that this act established isn't fair. So how isn't it fair? Is it procedurally unfair? Is it substantively unfair? Just simply that should not be a law. It's discriminatory. It targets non-government supported media, or it targets whatever. You have to be specific. And if you're saying that, well, we need to address that, well then what form of words addresses that? If you want to say, oh, well, it doesn't align with human rights standards, well, what does? If that's the weakness, and the way to strengthen it, as you say, is to apply comparative approaches and best practice and adopt some other standards, you're saying repeal it, make a new one. So this is all law reform for now. We're not strengthening law. And then it's got to do something just generally that complies with all of these international agreements. I mean, you're saying an awful lot there, and you're going to have to persuade me. And I don't know if you've got enough space to persuade me that specifically this is what solves the problem of fairness. It might be part of it. Okay, decisions should be able to be challenged. We have an aspect of procedural fairness here. But what is the problem, that certain acts cannot be challenged? Okay. So is that decisions of the tribunal can't be challenged? I'm not clear. Give me as much as you can. I don't have to research it entirely myself to give you feedback. And that this will then build confidence in the institutions, in the process, respect for the rule of law, etc. All of that sounds okay. You're going to have to flesh out the argument. Get rid of corruption. Great. That's a great way of strengthening law. How? If it was if we could just say that. So if we get rid of corruption, treat everyone fairly. What? Okay, so this student sort of is raising the closeness of government actors and certain media organization actors and their familial relationships probably. And they're saying that that's corruption. Yes, probably. But again, as an approach for strengthening the law, this course goes through 4 weeks of material on approaches to strengthening law. So do we want to, is it getting rid of corruption? Is that the approach? Or do we have different ways of framing that? Okay, and here's then the conclusion. So I don't know if that's really a conclusion. I don't really care if it's got more strengths than weaknesses or more weaknesses than strengths. That doesn't say anything. You're just saying, this is the act I'm looking at. These are the weaknesses. It is a current issue. I've identified these weaknesses and I've identified these approaches to strengthening it, all well referenced and evidence based. So again, think more about how you might structure that conclusion. Let me now go to the next example. And this one, if I've got it here, yes, there it is. All right, so this student has quite a comprehensive abstract. So I've said, you can read it, you can pause this, you can do whatever you like. I've said that this is pretty on track. It needs some revision, it needs some editing, but a few things I picked up on in here are the tenses. So I've been a bit more nitpicky about language and things here. This paper analyzes, right? Make this more succinct, make this more active. Don't start a sentence with while. We could say the issue of the usage, the issue of illicit drug use and related criminal issues, problems, wasn't significant in Fiji early on. I don't know where we're going here, and it's sort of we're wondering. Reports have shown a substantial increase in drug use, drug crime, all of these things. Be a bit more specific. What reports? Government reports? Court reports? Reports by somebody? Police, Fiji police force reports. Like, what are we talking about? Be a bit more specific and clear. Okay, this raises yep, you could say something a bit more sort of about, the needs of society, perhaps. Okay, and we've then moved to the need for multiple approaches to addressing drug use. So what the student's getting at here is that when you're dealing with, say, illicit drugs, you tend to find that there are strong correlations with low socioeconomic status, people who live in poverty, people who have had fewer opportunities for education, etc., etc. You also find people who are wealthy and otherwise act with impunity can also afford drugs. You can also find that people who are highly educated are the sorts of people that want to seek out novel experiences and therefore might be more likely to try or to have tried illicit drugs, but they might less commonly become problematic users. But we do see that illicit drug use affects everybody in society, from top lawyers to, politicians, police, and people in our communities. The goal of this paper is to propose so again, you can see how the language is we're losing the succinct mini essay, right? So the abstract is a mini essay. Again, this paper proposes the Illicit Drug Control Act should be reformed to include something, to do something, right? So analyzing statistical data, I'm not sure what this student did analyze or has analyzed, but nowhere here is it mentioned the PALS minimum standards framework. And that's what this student's talking about. Is the law understood? Is it responsive? And so not mentioning PALS is a critical error, because that's literally what your instructions are to do. So that should be in your abstract and it should be in your paper. Okay, and then the student is saying that this paper proposes several approaches for strengthening the law. 1, law reform. 2, I guess this student's proposing, in addition to custodial and, sentences, the law, this paper argues that the law can be strengthened by implementing complementary approaches to strengthen the law, such as education on, I don't know if it's just on morality. I don't think drugs are simply a moral question. Whether or not something is legal or illegal is not a question, whether or not a substance is legal or illegal is not a question of morality. It's just a question of fact. Either the law says it's illegal or not. I'll give you an example. The law in Fiji says marijuana is illegal. The law in Fiji says methamphetamine is illegal. The law in Fiji says, heroin is illegal. The law in Fiji says kava is legal. Or rather, it doesn't say it's illegal. The law in Fiji says tobacco is legal and licensed and regulated, as is nominally kava. The law in Fiji says alcohol is legal and licensed and regulated. Yet we know that combined, smoking and alcohol use are the cause of huge problems for people's health, NCDs, lung disease, cancer, a huge impact on medical services, and has an upscale effect on society. So, this isn't, and that's not a question of morality. If it was, surely it would be immoral when we see all the harm that these substances do for the government to say these are legal. It should be okay. What we're balancing here is the rights of individuals to choose what they put into their body versus the risks to society. And that is simply it's not a moral question. It's a judgment that's made on evidence and on facts. And in some places in the world, they've chosen to regulate these substances and not make them all illegal. Other places have chosen, similar approaches to Fiji, and different places pick different substances. Kava is mostly illegal overseas because it's a drug. In some countries, alcohol is illegal because it's a drug, right? So, whether or not it's licit or illicit is a question of fact. Anyway, so a fairly fleshed out abstract needs some cleaning up and needs the language to be tighter. but that's just a bit of editing, right? Okay, so then, okay, cool. So this student has sort of indicated that that's how they're going to structure it. But, you know, give me a bit more than just that maybe. Body, I've noted this is not a heading for your paper. This is like something that sits on the side in some sort of draft to remind you that, hey, this is the main part, but body is not a heading. And I've said here, look, it just describes that this is the main part of the paper. Your introduction, what comes under the introduction, introduces your paper. What comes under your abstract is an abstract of the paper. What comes under any recommendations are recommendations you've made. What comes under body is the entire middle part of your essay, which should have its own separate headings and should have its own separate structures under those headings, right? You've heard the adage, you know, one issue per paragraph, one problem per paragraph, one topic sentence per paragraph. And, you know, under your heading, if your heading is on, you know, is focused on his body, anything could come under that. How does that help the reader? How does that help structure it? So, yeah. And I've also noted that, you know, this sort of student has sort of continued this sort of strengths and weaknesses approach. That's a problem. Again, this is an exercise to help you identify strengths and weaknesses so that you can focus on the weaknesses that you think need to be addressed or strengthened in some way. So that's just work you've got to do on the side to identify the weaknesses. That's just how to identify them, right? And it's a very important exercise for you to do, but I'm not marking you on your strengths. I'm marking you on the weaknesses you identify using and how you categorize those using PALS. And the majority of your marks then will come, or the majority of your words for your paper, of the body of your paper, will be on your approaches to strengthening that law. And so this student hasn't reflected that. You know, they've got a couple of lines here for that, and then they've got all of this for explaining PALS. That's upside down. You need a very small amount for PALS and identifying whether the issue is an understanding issue, an appropriateness, etc. issue. And then I want to hear all about what you think should be done evidence-based. And so, okay, but what issue is this addressing? And a treatment center, what issue is this addressing? What, reoffending? Okay. So did you identify there was an issue regarding reoffending? And what is the problem with that? Is it a lack of understanding? Is it a lack of appropriateness? Is it a lack of something else? And I said that, so this is education, I guess, because we're talking about workshops raising awareness. And again, are people unaware of the effects of drugs on their health? They might be unaware of just how addictive it is. Might be worthwhile taking a few school buses to, you know, see some really hard addicts to get a sense of what you don't want to become, and so on. I don't think, you know, maybe helping identify, you know, ways that people can inform on the use of drugs or the sale and production or manufacture of drugs. Maybe there should be anonymous reporting mechanisms. I don't know. But again, what specific issue? So this is a lack of awareness or a lack of understanding, the student is saying. So again, ensure, and then discuss that. Well, workshops, what sort of workshop? Do these work? Has this ever worked? Has it ever been tried? Give me an example. Show me that it's been tried. Why are you saying that this is the right approach? What's your argument? Persuade me. Okay, well, you say that's the right approach. I mean, do you have any evidence that this approach will work? That's why you have to have the majority of your paper on this. This is the hard work. This is the important work. All right. So look, I think I've covered off those examples fairly robustly. If you have any questions, of course, you should email me, get in touch. Otherwise, I look forward to creating your plans, and we're going to go back to your lecture now. Okay, so we're back here with your lecture. So let's give an overview. If you want, pause, take a quick break, stretch, and then sit back down. You're only going to get about half an hour, 40 minutes tops for this lecture. You also have the additional, as I said earlier, discussion of the readings, which you really, really should also watch, already available at a separate link on Moodle. So last week in topic 7, we used the Guy Powell's minimum standards framework, and we said we're going to use that to help you identify weaknesses, or you're going to use it to identify weaknesses in law. And I explained that this is a theoretical framework that you can use to analyze whether laws are good in the sense of whether or not they manage to achieve those basic standards that the Guy Powell's minimum standards framework asserts are necessary. You know, laws should be responsive, understood, etc. While you don't need a theoretical framework to analyze a law, it's really helpful to guide your thinking and to give you a structure around which you can organize your arguments. You might intuitively know, well, there's a problem with the law, but you know, and the problem is, oh, well, we need more rehab centers. Well, is a rehab center going to solve all the drug problems or the problems with an act? No. So what problem does a rehab center solve? And well, it provides opportunities for people to recover from addiction and to have professional support and services to get out of that spiral. So it, you know, and there's probably a lot of research that shows that these are really effective tools to support people who want to quit, who are ready to quit. But the trouble with an addiction is that it feels good and it feels bad, but you physically need the substance. People who you know, have chronic alcohol addictions die when they stop drinking alcohol. I have a cousin who was an alcoholic, and he took a flight from Japan back to Australia, and it was delayed. And wherever he was delayed, he didn't, maybe it was late at night, he didn't have access to going and, you know, having beers. And all up, it was about 36 hours or more when he got back to Australia. And he was walking through Melbourne Airport and face planted. So he had a seizure because his body needed the alcohol to function. And once it didn't have that, it went into shock, withdrawal symptoms. And one of those symptoms was a seizure, you know, which and then he face planted on tiled floors, and it's caused fairly serious long-term damage for him. And most of you will be familiar with some of the other issues sort of that addicts get. So applying PALS means you're going to identify whether the problem with a law that you've identified is likely due to a lack of understanding, a lack of relevance, a lack of appropriateness, fairness, etc. Applying PALS, you can make a claim or an argument about what might be needed to address that specific type of problem given its specific nature. So if everybody understands the law, but it's not working properly because the law isn't appropriate or fair, then an education program to teach people about the law is probably going to be ineffective as a way of strengthening the law because it's not addressing the core issue that you identified by applying the PALS minimum standards framework. It's not addressing the issue that the law itself is not fair. Great, now I know more about how the law isn't fair. It still doesn't work, right? So from this week onwards, we're looking at a range of approaches that you can apply or add to your toolkit to strengthen law, to improve the performance of the law. Obviously, that sort of a thing should be combined with some sort of necessary law reform, which we talked about a lot in the first half of the semester. But quite often, the issue isn't that we need to change the law. The issue is that we need to implement it or implement it better or support its implementation in various ways using policy mechanisms rather than law reform mechanisms. In this course, we're telling you that you should consider all of these to be part of your law reform toolkit. That toolkit that you have will grow and grow as your knowledge and experience and understanding of law and society grows. Beyond law reform, there's many ways that we can strengthen the operation of law or the effectiveness of law, which don't rely on all the complicated, expensive, and time-consuming processes of law reform, but quite often can be just as inclusive, often more inclusive, involving communities and result in lasting positive change. Your toolkit is the starter toolkit, and obviously no one tool that we discuss over the next few weeks will suit all purposes, and as you'll discover yourself, a combination of strategies is usually the right approach as opposed to one single strategy. But it needs to be an appropriate strategy for an appropriate problem. Before I go on then, I just want to emphasize an important point about your analysis of a law paper. You're going to use the minimum standards framework to identify weaknesses in the law. You're going to might do a strengths and weaknesses, exercise and identify all the strengths and weaknesses, and then you're going to get your weaknesses. Here they are. And go to your topic guide, because there's a really clear example of how to do that there. That'll get you going. But once you've identified those weaknesses, choose 2 or 3 that you will then use in your essay to discuss how the law can be strengthened. You might start to realize that some weaknesses are easier to address than others, or are easier to solve than others, or are easier to solve using certain approaches to strengthening law than others. Hopefully you have evidence, references. Has this been done before? Where? How? Has something similar been solved? Where? How? And you'll recognize, if you do a good analysis of the law, that you can't, in 2,000 words, come up with some sort of well-reasoned and referenced paper that addresses how to fix all of those problems. If there's 5, 10, 20 weaknesses that you have identified, you could perhaps group some of them together, but to repeat myself, identify your weaknesses, know the strengths, and pick the 2 or 3 that you're going to focus on. Maybe that's because you can come up with a good approach for strengthening that aspect or that weakness. Maybe it's because, you're interested in it. So applying PALS, you might say, well, this law needs to be better understood by the community, so a great approach might be to implement an education program, workshops, something. Great, you're nearly there. What specifically then do you recommend? A workshop? Well, what sort of a workshop? Does anyone run these workshops? Who runs the workshops? Like, what's the nature of them, and sort of what are you trying to do? What's the outcome? What's the product? What's the learning objectives? What will be successful and why? Why do you think it's going to be successful? Why do you argue that workshops with traditional leaders of communities will, allow that education to filter its way through communities. Is that the approach? Or again, you're targeting schools and educating children? Are you targeting university students, workplaces? What's your education program? Are there other examples of this? Can you reference them? Okay, so that's probably all I'm going to say on that. What I'm going to do now is I'm going to switch to previous recording, which will cover the remaining slides, and hopefully you'll find that just as informative as students have previously. As always, any questions, problems, challenges, get in touch. So how do you do law reform? Do legal problem-solving methodologies equip you to do law reform? Why shouldn't it, right? It's law. You're lawyers, you're training to be lawyers. Why wouldn't that mean you're good at law reform? Well, the short answer is not really. Legal problem-solving methodologies, IRAC, ways we approach problems, they might get us to solutions to legal issues, but they might not be very good at getting us to satisfactory solutions to social problems. In the Week 8 topic guide, there's a reading 8.1, and I talk about it in the separate video on readings. But what we can learn from this is that when lawyers do law reform, they adopt an intuitive approach initially. And that's okay. It's just that we can't solve all the problems in the world based on our personal intuition alone. How accurate, for example, do you think your intuition is in representing the views of the whole community or those affected by a particular law? Your intuition about what will solve a problem in one place at this time or in the future at some point might not represent everybody's views. And indeed, what is informing your views? What's informing your views is your experiences, your education, your biases, the lessons that you've learned, the things that you want to communicate with others. And how do you balance your views against other views? Is your opinion even informed by evidence-based research? Maybe we base our solutions on the observations that we make about the world around us, but do we really understand what's happening in the world around us? Do you really understand why that man hit that woman? Do you really understand what that community views about whether that was right or wrong? Do you just perceive it as an unacceptable act of violence? I do. No man should ever be justified or consider he's justified to assault another person. What's that going to do? What's that going to achieve? On the other hand, if you are, say, a lawyer with a lot of experience in a particular area, if you have expertise, say it's family law, then maybe we might think that your intuition regarding the problems within family law, in domestic violence situations, adoption situations, perhaps even marriage, and what is right and what should be the case, we might think that your opinion as an expert is more valid, because who could know that area better than an expert like you? Well, that could be true, but that opinion of an expert is not gospel. What happens if the lawyer has a very conservative social set of values? What if they're deeply religious? What if they believe a woman's place should only be in the kitchen, that a man is the head of the household, or that women and children are property that belong to men? That's not a completely foreign idea in the countries and societies we live in. There's men who walk around who believe these things. Uh, there's men who sort of tut-tut and are very confused that 64% of USP's graduates are female. Why are there only 36% of men graduating? What are the men doing? Are they the ones doing work in farming and other sectors? Or is there a lot of women doing that work too? Where are the men and why aren't they stepping up? So we might expect that person with these traditional values to come up with different problems. When they look at the problem, say, of domestic violence, they might identify the problem as insolent women and disobedient children. And the solution is more beatings and more repression of those people. A different lawyer with different social values might see different problems and might find different solutions. Maybe a lawyer believes that her husband's place is by her side, not in front of her. Or a lawyer who is gay might just want to marry his life partner and be happy. Why should people, based on different social values, be prevented from being happy or accessing basic rights such as inheritance under law? So these individual beliefs and values are part of something that researchers call your positionality. Don't get too wrapped up in that, but that's your position. Where are you from? What is your place? What are your biases? Do you know them? Do you acknowledge them? So it's about thinking about how your beliefs and values limit or constrain your thinking, your experiences, your education, your way of being in the world is shaped by where you've come from. That doesn't make it invalid, but you need to acknowledge that that is just one way of being in the world, and that all around you are different ways of being in the world, some of which might offer better insights into the problems we have in the world and offer insights into better strategies or solutions for solving those problems. As you know, the USP School of Law fairly recently, in the last few years, has become the discipline of law. So the discipline of social sciences comprises 6 disciplines: psychology, social work, history, sociology, gender studies, and Pacific policing. So if we're trying to understand a complex issue like gender-based violence, or violence by men against everybody, and how relevant laws can be reformed to better combat that complex issue in our society, it's clear that all of these different disciplines can come to the table with different knowledge and different ways of viewing the same problem in the context of where the problem is occurring. In our homes, in our villages, in cities, in nightclubs, in schools, on campus. We can understand, for example, that violence against women and children has historical and cultural sources. We can understand that some men justify violence against women and children based on their religious beliefs, because somewhere in the Bible, the man's the head of the household. I don't recall the part where Jesus said, and then you must beat your children and beat your wife if she makes you feel emasculated because she's out earning you and outperforming you at university. I don't see that anywhere, but you know, there's men out there. Violence against women, we can see from a social perspective. It's an act by a patriarchal system, which has long protected violent and abusive men. From a policing perspective, we might understand that violence against women has certain patterns, such as where or when or how it occurs. We might find it's more common on weekends after men have gone out and gotten drunk. We might find it's more common
during festivals. We might find it's more common during lockdowns. We might identify that the problems that we see have patterns that we can observe. And if we can observe those patterns, we can maybe develop better strategies for preventing the problems. Or, we might put on more police during those times. We might fund extra domestic violence support services during certain peak times, etc. And a psychologist might tell us that behavior therapy for violent men is essential, that you can't change the way that somebody acts without changing the way that they think. And so all of these different perspectives, these different disciplines, can bring something to the table when we're thinking about reforming law. So in this slide, we're drawing from your topic guides, and I think there's just one key message to take away on this slide, and that is that intuition is the place that judges start when deciding cases that are beyond existing law. So you're a lawyer thinking in your legal set of, parameters. In all of the cases that we deal with, there's some element of judicial discretion. And what's that talking about? That's sort of just what the judge thinks. The Vanuatu Constitution, for example, requires judges refer to substantial justice when relying on discretion. In other countries, the same or similar or no such consideration is required. Yet, even though that requirement's enshrined in law, or in this case in a constitution, it requires the judge to make a subjective decision about what substantial justice even means in the given circumstances. And that will be different depending on the circumstances. So it boils down to, well, what does the judge think? That sounds kind of scary. Are we just subjecting ourselves to the justice of whatever a bunch of well-educated men think? Well, actually, yes, that's a lot of what the justice system does. So, we need more female judges, we need more diversification on the bench, and so on. But there is a pretty big accountability process in law. Decisions must be published, and they can be appealed if the reasoning is faulty. So to ensure that there's consistency and accountability and that good decisions are made, we expect judges to base decisions on some sort of rational or critical argument, ideally based on the submissions actually made by the lawyers in court. Hopefully the lawyers are skilled and competent. It doesn't sound like a perfect system, right? But that's really where we need to start if you want to solve a social problem. Look around you. What's the issue? What does your intuition tell you are the problems? What does your intuition tell you are the solutions? Is a starting point. That's not where you need to end up. Whether or not you want to use law or law reform as part of your way of solving the problem. If you don't really have much intuition about what a problem is or how to go about fixing it, or your ideas of fixing it are very blunt, like we should reintroduce the death penalty and this will prevent gender-based violence, then to me that's a clear sign that you need to do some more reading and maybe some more note-taking to get a better sense of what the problems actually might be and how we might actually go about solving the problems. This slide makes much the same point as the previous. Law reform commissions go about solving problems in much the same way as judges. At the end of the day, you've got a human or a committee of humans who weigh the various options that they receive during the consultation processes. If the person who is in charge of the Law Reform Commission or that committee has their eyes closed and their ears closed, or is only listening to what they personally intuit or believe, then obviously the range of options that are considered for law reform and that are considered to be viable for solving the problem will also be limited. Because it all boils down to, well, what does the law reform body think based on some sort of rational argument that they're going to write down, which seems to us best. As with a judge, they publish these opinions publicly in a big document that's heavily scrutinized, and it requires clear and defensible arguments. And I think that's something we can take away, that most of our law reform processes and the ways we make law at some level rely, at least initially, on intuition and then on some sort of evidence-based arguments for solving whatever the problems are. In this course, we're talking about your law reform toolkit, and we're talking about identifying solutions, so intuitively identifying problems and solutions as a starting point, and then starting to use different theories or different strategies for strengthening law that might add a little bit more structure to the way you're arguing about or for the solutions that you're arguing for. There are almost always negative impacts or consequences of every attempt to legislate to make things better. This intuitive identification of solutions, when we think about what that means, well, there's a few things that I think about. Firstly, I think that collaborative and consultative approaches to coming up with solutions almost always lead to better outcomes, better understanding, more appropriate, more relevant laws, and things that are more likely to work in the places that they're designed to work in. Importantly, that should lead to better compliance with the law, which is ultimately what we're trying to achieve. Some macro, high-level, overarching solutions to problems are obvious. If you want to stop fish stocks from crashing, our fisheries are collapsing globally, the last good ones are in the Pacific, we need to reduce overfishing. That's a pretty simple answer to the problem, and yet we're not doing that. Our waters aren't protected. There's huge fishing fleets all around our islands. So, okay, we've got a solution, but not overfishing isn't working as a solution to the problem. So it's clear that the problem's a lot more complex, and our solution requires a bit more thinking and a bit more nuance. The problem for pollution and littering. Don't pollute. Don't litter. It's that obvious. It should be that easy. But it's not. Children throw rubbish on the ground. You go to any big event in Suva, hosted at a park or wherever, and there is styrofoam and plastic and rubbish as far as the eye can see. That is the same in many other countries in the region. So why do people who wouldn't throw rubbish on the ground in their own home consider it's okay to do that in public? Where does that disconnect in their thinking come from? And how can you address that? And the solutions we come up with are almost always going to require multiple, complementary, parallel approaches. So consider one major issue, the issue of littering and pollution, rubbish choking our waterways, our streets, and so on. A lot of countries have implemented bans on single-use plastics, like styrofoam containers, plastic bags, and drinking straws. Okay, so there's multiple ways we can try and prevent these things from being pollution. One approach is to ban them and then fine any business that sells those products or gives them to customers. Another approach is to require the businesses to pay a small fee, which they then pass on to customers, 5 cents, 10 cents for a plastic bag. Another approach is to provide incentives to small local businesses, for example, to manufacture alternative environmentally friendly products made from bamboo or banana leaf. Another approach might be to introduce high penalties for commercial industries and businesses who dump waste. Another approach might be to organise a police blitz on littering and perhaps a national anti-littering campaign headed by a popular football star with competitions for schools and villages for the most tidy village or school, or for developing the best recycling solution in their community. Another approach might be to develop a short program to teach within the regular school curriculum, so that school kids in primary school and high school and beyond learn more about environmental protection. Maybe there can be school projects that teach practical environmentalism and so on. So perhaps the best approach is to combine some of these, or all of them. Or based on our readings, if you've done the readings, maybe a good strategy would be to rely on our weak institutions and to offer incentives to different groups to innovate local solutions for local littering and pollution problems, and then evaluate those different solutions to see what has been the most effective and why, and then perhaps supporting other places that haven't had effective solutions to take on those effective solutions that might work best for them. Maybe they can choose and try. So whatever the problem is that you're dealing with, pollution or social welfare or violence or election reform, every solution needs to be tailor-made for the place that it's going to apply, which tends to mean that we need to mix and match law reform with activities that strengthen the effects or the implementation of that law. So from the discipline of law, there's no clear method for law reform. Judges make decisions that develop law, but there's no really good method. It's sort of intuition and there's some argument and then we get judicial decisions. Law reform commissions develop recommendations for law, but again, it seems to be a bit based on their intuition and what they think. And so this is where law has to meet reality. As lawyers, you take the law as it is, you consider the intentions of the law, and you provide advice to a client based on that. As lawmakers, you need to assess what the law is and also how the law should be. And how the law should be requires a very nuanced understanding of our society's expectations, the constraints on our institutions, the constraints of our environments, and so on. And all of these aren't learned inside law books. Your topic guide gives you an exercise which encourages you to brainstorm ways of dealing with littering and pollution. I've also just done that for you a little bit. It could be littering at schools, so you could pick an issue littering at schools here. I want you to come up with, if you're going to do the exercise, come up with 5, 6, 7 different issues. Maybe it's littering in school, or it could be littering on buses, or it could be littering at Maisuva Park, or littering down by your seawall, or littering by big events. So it could also be pollution by farmers into rivers. So write down the issue, identify a possible solution, what are the advantages of that solution, and what are the disadvantages. Maybe it's very expensive. Maybe it's very hard to police and enforce. Maybe it's very hard to access the place where the littering is occurring. Maybe the solution is short term. Maybe the solution is long term. So what are the pros, what are the cons? Just as an exercise to warm up your intuition. You could then apply that exercise to whatever topic you've chosen for your individual plan. To use your law reform toolkit, we've got some clear steps set out in this set of slides. Firstly, identify the problems. We've got your intuitive exercise. That's good. There's your brainstorming. But now for your position paper, for your individual essay, your argumentative essay, I want you to identify problems. You might have brainstormed them already. And I want you to explain them in terms of the PALS minimum standards framework. And if you're really not sure what that framework is, you probably haven't watched the week 7 lecture or done any of the readings from that week. So after you've done those, maybe come back here and continue on. Or if you still have questions after you've done that, get in touch with me and I'm happy to discuss the expectations with you further. The second step, analyze your options or solutions. Okay, so here I want to talk about one important thing. I mean, we look at comparative analysis. That's one way of comparing different solutions. We can look to best practice from other places, but that doesn't necessarily give us much insight into what works in our local community. And one way we can get more insight is through what we're calling here impact analysis. This is an analysis of the potential changes caused by a proposed strategy or new strategy or a product or an application or some sort of regulatory intervention and the consequences of that. To give you an absurd example, one solution to preventing crime is to drop a nuclear bomb and kill everybody. That's going to be 100% effective at reducing crime in Suva City. But the impact of that will be to turn Suva into a radioactive crater filled with seawater. That impact might be viewed as undesirable by most people. So similarly, for any strategy you propose for fixing a social problem, whether it's housing, land, violence, marriage equality, environmental protection, government accountability, there will be consequences, both intended and unintended. And as a smart, university-educated future, and some of you are current leaders of our societies, you're expected to consider the consequences of your ideas and maybe consider how to mitigate the negative consequences of the good ideas that you have. So in your readings, communicative action is discussed. There's a link in the readings to a paper by Habermas. And it tells you that communicative action refers to a process for developing strategies for addressing the complex problems we face in society. Communicative action refers to cooperative action undertaken by individuals based upon mutual deliberation and argumentation. So cooperation, mutual deliberation, some tok-tok, a talanoa, and respectful arguments. This might sound familiar to the way problems are discussed or solved in your family, in your church, in your communities that you belong to, but also in those places you might have strong hierarchies that minimize the voices of certain groups, young people, women, or not. And communicative action refers to something a little bit more equal. All voices are respected. We might still decide that we have to rely on traditional authority or charismatic authority to achieve what we want to achieve and to make sure that the solutions we come up with are long-lasting and work. But communicative action is the process of getting to that solution. So as an example of, say, charismatic authority, what is being done when a football player comes on TV and says, "Hey kids, don't throw rubbish," is that person is using their charismatic authority to influence the behavior of people in society. And in doing this, they're promoting this positive ideal, this new way of behaving. Don't litter. And stigmatizing at the same time the behavior that we want to get rid of, littering. That the rational authority, the state, wants to stigmatize and prevent. We don't want you to litter, don't drink drive, etc. You will make the Fiji 7 sad if you throw rubbish on the ground. Sad face, don't litter. Okay? So these are ways that we can use to strengthen law that don't involve changing the law to, we don't need higher penalties for littering. We just need more social stigma around littering. We need more people, if they see someone throw rubbish on the ground, to say, "Hey, pick up your rubbish. Why did you put the rubbish on the ground? What does this look like? Your home? Do you throw rubbish on the ground in your mother's kitchen? Pick it up, put it in the bin, or carry it with you until you find a bin. Don't be a pig," and so on. We need to stigmatize the things that we want to prevent and promote the behaviors that we want to promote. And charismatic authority, the rewards by traditional authority, these are ways of doing that. There's a lot more on communicative action in your topic guide, and you should work through the study tasks there. You'll see on this slide that we talk about the social contract, and you might look back to the topic 4 notes and week 4 materials regarding different ideas about society and what we want our societies to be like. So on this slide, we can see that there's 2 different things we're talking about. We're talking about maybe strengthening the social contract. So this is this glue that holds our society together, what we stigmatize and what we promote. Maybe we strengthen the social contract between us by improving understanding of the consequences of littering, of the impact of violence on people, of the impact of improving participation in elections, the reasons why constitutions might need to be reformed in certain ways. These strengthen our social contract. By contrast, if we want to strengthen the performance of the law, well, we might also want to communicate and get people to understand why that law is important and why it must be the way it is. We might strengthen institutions like police or courts or anti-littering squads or fisheries groups. We might need to reform our institutions. Maybe our departments operate inefficiently. Maybe the Ports Authority could be run better if we want to strengthen the performance of laws relating to shipping, say. And other ways to strengthen the performance of the law might be law reform to change the content of the law, decolonize the law, update the law that hasn't been updated in 40 or 50 years, and so on. So ideas that strengthen the social contract we can sort of think of as big picture things, and strategies that relate to, say, a specific law, like the content of the law or the, reforming an institution that oversees the law, more like strategies for that lower level task. So big picture and then specific, the broad, the narrow. With strategic action, An actor has an end in mind and is trying to influence the decisions of a rational opponent. With communicative action, two or more actors establish a relationship and seek to reach an understanding about the situation and what needs to be done, and what each of them needs to do and what other people need to do, and they try to coordinate that by way of some sort of agreement. Okay, so you can see that communicative action is a bit more community-minded and involved, and helps us tailor make our solutions to problems to our local situations. The way I would organise a meeting of stakeholders and discuss an issue in my community here in Canberra would be different from how you do it wherever you're tuning in from, or in a different part of your country, or that I would use in a different part of my country. And it might be different for different issues, okay? It requires a flexible approach based on what will work. And that comes from intuition, that comes from your knowledge, that comes from talking to people. And it might require you to do some big thinking. On this slide, I pose a question. Is a position paper, such as you did for the group assignment, communicative action, or is it an example of strategic action? Well, it should probably be an example of strategic action, right? You're identifying a problem with a law, a current development in law, and you're talking about specific solutions to that law or the problems to fix the problems that you identified. So that would be a strategic action. A submission or a position paper isn't about reaching agreement. It's one way. It's saying, this is my position. But your position paper could recommend communicative approaches be adopted. Or it might be a precursor. You prepare a position paper, but then later on in this consultation process, you're invited to a talanoa or a formal public consultation, which are part of a communicative approach to solving the problem that the government is trying to solve. In your topic guide readings, there's a study task which asks you to look at papers on constitution making and reform. The key points are shown on the slide, but click that link and go to the relevant page numbers. The three ideas there are, if you want to consult with people, it helps to develop a map of who the important actors are and what their relationships are to one another and to the problem. It helps to identify who should be responsible for what and where and maybe even why. And it helps to understand the purpose of whatever it is that you're working on. In this case, a constitution, but in other cases, what is the purpose of that domestic violence act? Can it eradicate violence? Is that a realistic objective for the act? Or even if that's an objective, do we hold it to that standard? Or do we hold it to a standard of how effective is it at reducing violence? Or how effective is it at providing protection orders? Or something like that. And that's all we have time for, and all we really want you to understand this week. Make sure you check out the readings and watch the additional videos that have been uploaded in relation to your readings. If you have any questions, please email me, please get in touch. Always very happy to arrange time to speak with you one-on-one. Bye for now.